Hi guys. So I when I did my videos with the recent court orders from Judge Lyman, I was reading them for the first time. And I quite often like to just sit and think about things. I gave some kind of brief opinions at the time, but I then go away and I have a think and I sort of look into the law and maybe, have more I want to say. And this is one of those videos. Um I also kind of wanted to do this because of some of the comments I was getting actually. All completely respectful. There's no criticism at all. Um, but I think there may have been a bit of confusion. Um, and I wanted to sort of clarify, not tell people that they were wrong or that someone else was wrong, but just sort of give my opinion on it. Um, so there's a couple of areas. There's this order on Leslie Sloane's fees and costs. I wanted to sort of clarify my views on that. I wanted to talk about Freedman. Did Freedman fluff up for Wayfarer? Should he be sued? Oh. And my views on that. And then I also wanted to just because it all ties in with Leslie Sloane in particular, but I wanted to go over James Vituscka again. So let's start here. There's problematic areas of this. Now, people are sort of saying, oh, this is a win. I don't think it's a win. I'm sorry, I don't. So Leslie Sloane was obviously denied her request for attorney's fees and costs. But, and I said in my video, I was like, is Judge Lyman saying that, he would have sanctioned him? Is he giving an opinion that Wayfarer did something wrong or falsely attributed a defamatory statement to Leslie Sloane? Like, is he saying, well, if Leslie Sloane had filed sanctions, I probably would have granted them? What he did actually do categorically was he denied without prejudice and pretty much invited her, like suggested to her, no, go and file a formal motion. So let's go through that. My first statement that is problematic is this one. This is his opinion. It appears that the accusation it appears that the accusation against the Sloane parties was false. It may have been knowingly false. That's his opinion in this order. And I have absolutely no doubt that when Leslie Sloane goes to the state court, which she will, and files, she will refer back to that. Now, there's two other areas of this order I have. Well, there's a few areas, but he cites James Vitusca's declaration. So I'm going to go back to my threads for this because I did a thread on it. Let's have a look. A brief background, and I know I've done this before, so for anyone who's already heard the video where I've done this before, sorry if I'm repeating myself, but just really, really, really short and to the point. So obviously there's been a back and forth over the meaning behind James Vitusca's messages. Now, my solid opinion, which is not wavering at all, is that he is a two-faced weasel and has been playing people off against each other. That is my opinion. So, May the 1st, Sloane filed her motion to compel. There was a footnote here. I had to correct Sloane. That's such a me thing. But obviously these are I mean, like I say, right, if someone's done a good job, I don't care what side it is, I will point it out, and I did actually do that here. I said there was a discrepancy. So Yeah, it's hard to see the screenshots. I will try and bring them up, but it is hard to see. But I did quote James from Daily Mail to Melissa Nathan. She said the whole cast hates Justin. I put hits because that's what it says in the. I've literally quoted the text. The whole cast hates Justin. This has nothing to do with Blake, and now she's saying that Blake was sexually assaulted. Why wouldn't she say that? Why wouldn't she say anything about that then? James from Daily Mail later on to Brian Freedman. I've had many conversations with her about Blake, and never once did she say anything about sexual assault. I had a three-way call with her, Melissa, and she said nothing. She never said anything about this then. Now, this is where I got my negative opinion of James Vituscka, right? Is because he's contradicted what he said to Melissa Nathan, and then he has said something completely different to Brian Freedman. And I'm sorry, but details like that really get to me. They do. It could have been a mistake, right? People do it, they say, "Oh, I said this," or "She said that," and they may in their mind have thought, "Oh, you know, I said this at the time," not realizing that actually that's not what they said, but it may be it may have been what they wanted to say, and they're recalling that, and without the information in front of them, it may be, just a misremembering issue. I don't have a problem with that, right? But Sloane is right to point out the discrepancy and question it. That's not what I want. Yeah, Sloane was right to point out that discrepancy. Now, at the end of May, Sloane filed a motion to compel where she made some good points. I was waiting for Vituscka's response. Hold on. One more. Hi, guys. So I did my videos on the orders from Judge Lyman recently, specifically the content creators, the Leslie Sloan, attorney's fees and costs, and the sanctions, the Rule 11 sanctions against Wayfarer's counsel. So when I was doing the videos, I'm reading the documents most of the time in real time for the first time. Even if I haven't, I might have given it a cursory skim and then done a read through on the video. I will often go away and I might come up with some new thoughts, or I might read the comments I get as well, some points that people make, and think, do you know what? I'm gonna do another video, actually go into a bit more depth with my opinions, and maybe just try to clarify some of the comments, clarify a little bit, because give more of my opinion. So, and this is one of those videos, actually. So this is not to tell people they're wrong or that another content creator is wrong. Absolutely not doing that at all. It's just to clarify a bit more about what my thoughts are about some stuff, because I've had well, we're going to start with the Leslie Sloan, actually. I'm going to do a separate video for the content creators. I've listened to Cassidy's video and talked to Cassidy and Lauren, actually. And I have things I want to say. So I'm going to do that as a sort of separate video, I think. So here, I want to just go through the Leslie Sloan order first, because this is being touted as a win for Wayfarer. I'm sorry, I don't agree with that. I don't. It is not a win, and I'm going to talk through why I don't think it's a win. And some of it I did actually point out, although I didn't go into too much depth on my video, I did point out certain points where I was like, is he saying that Leslie Sloan, if she'd filed Rule 11 sanctions, he would have granted them? Is he telling her basically, Wayfarer have done a bad thing here, you take it to state court? Because I got the impression that's what he was doing from the wording. I did not like the wording. But I just needed to kind of go away, read it over a few more times and kind of take it in. because a lot was kind of happening on the docket after weeks of silence. We suddenly had court orders coming out left, right, and centre, not just on the library docket, but also on the Jones docket as well. And I just kind of needed to sit down and process it. So, this first statement at the top here, it appears that the accusation against the Sloane parties was false. It may have been knowingly false. I just want to point out, Judge Lyman is stating that as an opinion in this order, as his opinion. Now, I have absolutely no doubt that Leslie Sloane is going to file a state lawsuit for the attorney's fees and costs, same as the New York Times have. I 100% believe she's going to do that. She's looking for over $1 million. So why wouldn't she? And I'm telling you now, I will come back in a video when it happens and I will point out that I said that she will refer to that statement in her lawsuit. She will absolutely refer to that. Judge Lyman said that the accusation against us was false. He even opined that it may have been knowingly false. She will do that. And that's why I'm a bit annoyed that he's been he's obviously not stated it as a fact, but he has stated it as a rather a persuasive opinion. And the reason I'm going to get annoyed about that is because we will see, actually, he heavily refers to the declarations of James Vituscka. And I think I have made my feelings about James Vituscka very clear. I think he's a two-faced lying weasel, myself. I think he played people up against each other, myself. But I am going to, for the sake of completeness, I have gone over some of this before. I'm going to go back over it again because since I've done my video and since I did my my initial thread on his declarations, we've actually got the full thread of those text messages. Not just that one. You see, this is a problem when you take messages and, like there's no context, right? It looks and reads a certain way. But we now have the full interaction and the interaction between him and Melissa Nathan between these two declarations being filed. And I think this is all important context. So, if we go to, right, so the reporter has since been identified as James Vituscka. The Sloan party submitted a declaration to this court signed under oath by Vituscka on June 4th. Okay, let's start there. My thread on X. Let's have a look. So obviously there was the background is motions to compel, etc., etc. Then on June 6th, he filed his declaration changing his story entirely. Changing his story entirely. Before we go there, though, we had James Vituscka's response. I quite liked it at the time. I was impressed. And as I put here, it allowed me to go nuts with the color highlighters. Okay. So, one of the things that this motion to compel actually, this response to Sloane's motion to compel actually states is in the footnote here that during a meet and confer, the Sloane parties told Vituscka and his counsel that they expressly reserved the right to move to compel seriatim on the remaining subpoena requests. So there were a new number of requests in the subpoena. I don't know exactly how many. I don't know if it's here. But there were a number, and basically Sloane was kind of threatening Vituscka and saying, right, compel, or I'm just going to, hammer you with motions to compel. So, where is it? So then we move into June the 6th, right? Now I thought that was a great response, and I was actually looking forward. I was like, well, he's a certain journalistic privilege, right? And he's saying, I've not waived it. Now he was a journalist. Leslie Sloane, really would have struggled to get around that. She tried to assert journalist privilege for herself, which was hilarious because she's not a journalist. And Judge Judge Lyman pretty much, said no to that anyway. But I think if he'd stuck out that battle, then that would have been the end of it. But something made him cave. And then we had this. The first declaration. He says, I used the phrase sexually assaulted in mistake. I meant to say sexually harassed. He says the praise was not in reference to any conversation I had with Leslie Sloane. Miss Sloane never told me that Miss Lively was sexually harassed or sexually assaulted by Justin Baldoni or anyone else. He then goes on to say, the Wayfarer parties and their counsel did not consult me about what I meant by my use of the term sexually assaulted. Which annoyed me because I think it's for him to say what he means and get the term correct in the first place, actually. As I did not authorize the Wayfarer parties or their counsel to include my text messages in their filing. Now, again, that annoyed me because he kind of inserted himself here, and then he was, upset with the result. Sorry, just okay. But then we had this. This is not great when I blow it up. Now, if at some point, I think this came possibly after the second declaration, it turned out that James Vituscka had been talking to without a crystal ball. And this is a red lines of that same declaration. And he basically holds Sloane responsible for this. He says, it was basically a misunderstanding. He says that what is it? Yeah, there was an error. So he was referring to but he meant the phrase in the complaint against Blake Lively, and I think he was kind of shocked. But the way it's worded, when you read it, it does look like he's saying, "Oh, because it's actually in the midst of a conversation about Leslie Sloane with Melissa Nathan." So I can see how that mistake was made. And in fact, I'm going to go to the message directly, actually. All right. Okay. Let's share this. So this is a text message thread between James Vituscka. James Vituscka is on the right. Those are his messages, and on the left are the Melissa Nathan ones. So they're actually talking like, Leslie Sloane has a personal vendetta against you, and I know this because she's told me. Melissa Nathan says, I know. And then he says, that has to play into the lawsuit. And then Nathan says, well, she'd said I ruined her client's reputation to my face. And Vituscka says, I'll back you on that. Sorry, there's a nice green van going by. I'll back you on that. I think at this point they're kind of crossing over messages. I think he's prepared to back her on the fact that Leslie Sloane has said that she has a personal vendetta, not anything to do with ruining another client's reputation. And he's still talking like, he's still in his own bubble, like, on the stand if I need to, or an affidavit, whatever it takes, etc. Some screenshots, here you go. So we don't get to see what those screenshots are. But he's sending screenshots. The vendetta is laid out in her words in many texts. Feel free to use them. Feel free to use them. But he didn't. But at the same time, right, according to that declaration, he did not authorize the use of his texts. Isn't that what we just read? I'm pretty sure that's what we just read. And that is what that is what this red line actually says. Like, because he's actually crossed out the words "not authorized" and changed it to "I did the way the Wayfarer." He should have said just cross out the "not," I think. But basically he says underneath, "I would not need to authorize them. The text included a party in the lawsuit. I told my former counsel this in emails." So it's, bear with me, but it's just stupid. Now let's go back to these text messages. Right, and then he goes on to say the vendetta is laid out in her many words. Feel free to use them, right? So, and she says, "Thank you, thank you." And then he sends her more, right? He said, and she says to him, "Send all. I'm on with Brian. Recross complaint, which you will get first." He says this shows what a liar she is, and sends more stuff. But then here's that message, right? She said, now in the midst of talking specifically about Leslie Sloane, you can forgive Melissa Nathan and Brian Freedman for maybe misunderstanding this, right? She said the whole cast hates Justin. This has nothing to do with Blake, and now she's saying that Blake was sexually assaulted. Why wouldn't she say anything about that then? I'm sorry, but I think the average normal person of, sufficient intelligence would read that as he's talking about Leslie Sloane. He's also talking about she's saying that Blake was sexually assaulted. Well, if he's not talking about Leslie Sloane, who else is he talking about? And then he goes on to say, she knows she is full of shit. And they're still talking about Leslie Sloane after this message. She told me that the whole issue was that everyone hates Justin. Nothing about Blake and Justin. She said it's everything to do with Blake. Bullshit. So why on earth would Wayfarer not take that message to be James Vituscka saying that Leslie Sloane told him that Blake was sexually assaulted? This is what pisses me off with Judge Lyman when he puts this stuff down, because he's looked at that declaration and gone, well, he said that. Okay. So let's go back to these declarations. That was the first one on June the 6th. Actually, let's go back to that, which was just, rubbish. Because he clearly did authorize the text messages to be used. So his declaration was wrong there. He clearly did suggest or imply that Leslie Sloane had, told him that Blake had never said to him that had told him that Blake Lively was sexually assaulted. Now, he may not have been clear enough, and that may have been a mistake. And I think I could have forgiven him at that point. Then, so those messages come after this first declaration. But then we go on, and there's another declaration filed on August 21st. Here we are. The new declaration. Where is it? So, and I know Judge Lyman refers to paragraph 4 here, where he says, while true, the initial declaration did not include everything I wish to say, and that he repeatedly raised to his former employer, the Daily Mail, that he wanted to provide additional information. He also says that the Daily Mail would not allow him to do so in or with his initial declaration. So then he goes on and he says, that the initial declaration was prepared and presented to me under intense pressure. That the attorneys who purported to represent him in drafting the initial declaration were appointed by his then employer, the Daily Mail, and he was implored to go along with their draft and legal framing under threat that failure to cooperate would jeopardize his job and legal standing. So we then got another, he then then he was terminated then after filing a whistleblower report. He believes that his termination was retaliatory, and he now wants to explain further the communications with Leslie Sloane, Melissa Nathan, and Brian Freedman. Now, he says here in paragraph 8, in both the original and amended complaints filed by the Wayfarer parties and Mr. Freedman, I am described as having said that Leslie Sloane, Blake Lively's longtime publicist, told me that Miss Lively claimed Mr. Baldoni had sexually assaulted her. That allegation is false. I never heard Leslie Sloane make any such statement whatsoever, and I never said she did to anyone. Now, I am a bit confused because we all read that. We all read that and those messages, and we can kind of see what is going on and how what was basically a fairly innocent mistake was made. Okay. And then further on, he then says, I've come to understand that the Wayfarer's defamation lawsuit against Miss Sloane and Miss Lively was based in part on the allegation that Miss Sloane told me that Miss Lively was sexually assaulted by Mr. Baldoni. Not only did that never happen, I told Miss Nathan and Mr. Freedman in writing on December 25th, 2024, that it never happened. I was shocked when I learned that these allegations in the amended complaint were based on a statement that was never made, after I'd been very clear about that with both Miss Nathan and Mr. Freedman. And when I express great skepticism here, because that statement bothered me at the time, but him saying, I was shocked when I learned that these allegations in the amended complaint were based on a statement that was never made. They weren't just in the amended complaint. They were in the New York Times complaint. There's the one that started in California. They were in Wayfarer's initial complaint against Lively in New York, and then they were in the first amended complaint in New York. But he didn't bother saying anything until June, and then clarifying further in August. The amended complaint was filed on the 3rd of February, and he said nothing until, at the absolute earliest, the 6th of June. But he was shocked. And then we see his text messages with Melissa Nathan on the 29th of June, where he's like, I'm not sure if we got there, actually. Let's go there. Yeah, let's go there. So let's look at his messages. Let's have a look. Yeah, because here we go, right? He's just read the documents. This is, what date is this message? This is the 24th. You can see there, what? Just read docs. This is getting insane because they're not telling the truth. He's talking about Blake Lively and Leslie Sloane here. And he's saying this to Melissa Nathan. And then he goes on to say, we both know the type of people that Leslie and Stephanie are. It will come out in the wash. So, well, this is redacted. So this is the 29th of June, right? James, hey, can you please call me? This is after his first declaration. I don't know what's going on, but no matter what it is, I can take it. For 3 weeks, all I wanted was this declaration. So that deck is meant to mean declaration to be withdrawn because it's not truthful and contains information I told them not to include, and because I was forced to sign it. Now everyone's acting strange and no one is responding to me. She responds, "Morning, I'm a little under the weather with giant migraine. There is nothing else happening to my knowledge. I sent all to Brian Freedman, and he didn't say much more to me. I'm not in direct contact with Mark." This is Mark. This is Mark Garrigus. Yes. Yeah, that's right. As Freedman's like a friend, basically, and another attorney who is Freedman's friend. She's not in direct contact with him over any of your situation at all, so there's nothing off and happening at all our side. You need to get hold of Mark and team and ask what the fuck is going on. I wish I had all the information on your stuff, but I don't. I'm drowning in our stuff and all the shit they are throwing at us non-stop. You have to ask him for a call ASAP and tell him you need a plan for this week and you cannot just wait around and see, especially now you have lost your job due to Leslie Sloane's actions. They need to tell you what their plan is ASAP. He then says, "Okay, thanks. I thought you were mad at me for some reason. I'm sorry you're not feeling good. This shit really takes toll on your body and mind." So we continue. We're going to continue. Yeah. She then says, "Oh my gosh, I'm not mad at you at all. I feel absolutely desperately unhappy for you. I feel so unhappy for you. It's made me even sadder. And yes, this has taken the biggest toll on all of us. Your mind, your body, exhaustion, and you can't sleep. And all because of some fucking stupid fucking egotistical maniac. Can't believe that no one liked her." Yeah, she's talking about Lively there, by the way. And we all agree. Yes, that when I was subpoenaed, that's exactly what I said. She just can't believe that no one liked her. I just can't believe I'm in this for the sake of a 3-week period. I can't believe that. And then James Vituscka says, "I can't believe that Daily Mail is blaming me for articles that they benefited from and fired me after we filed a whistleblower complaint alleging that I lied and I said in court documents that Justin Baldoni assaulted Blake. This is what the company told me in their letter of termination." I was like, Jesus Christ, not this sentence again. They also said that I had to be removed from every story on Blake since January, and I've only done 92 in actuality. Anyways, it's all water under the bridge now. We can all focus on the future. I'm praying that there will be a way for our truth to shine through. Our truth. He's saying this to Melissa Nathan. Our truth. She says same. He says, "Keep the faith. I'm always here for you. Sorry for the freak out." And she says, "Listen, it's hard not to freak out. I'm always here." Right? And then a few more weeks later, he files that second declaration, doubling down. I never said this. Not only did that not happen, I told Miss Nathan and Mr. Freeman in writing that it never happened, blah, 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 blah. I'd been very clear about that with Miss Nathan and Mr. Freedman. And then clarification of the record, the paragraph 13, by filing a lawsuit based on falsely casting me as the source of a sexual assault allegation, Mr. Freedman, his clients, and those apparently aligned or acting in concert with them have caused immense harm and I believe misled this court. They've damaged my reputation, cost me my employment, and undermined my career as a journalist. I'm sorry, did everyone enjoy that ping pong of, James Vitusca's version of events? Because it is hard to keep up with this man, right? He did say it, and you could see how it got, kind of absorbed. They were talking about Leslie Sloane before he wrote that message. They were still talking about Leslie Sloane after that message. I read it as he was talking about Leslie Sloane and, implying that, oh, she's now saying that Blake, Justin sexually assaulted Blake. I read it that way, and I'm not a fucking idiot, and neither are you guys, right? But I could see that this could have been a mistake, right? And he should have just clarified, "Oh no, that's not what I meant," at the very earliest opportunity. Now, he does refer to a text message where he says, "Oh, I made it very clear that I didn't say this," but that was, there was a lot of skepticism about that text message. There was problematic. It was, I don't know. It just felt like it wasn't authentic. And there are other things as well that bother me. So, where is it? Ah, here it is. So these are messages that he sent to without a crystal ball, right? And he says, I was alerting Freedman that Daily Mail will fire me for exposing Leslie Sloane as my source in messages that included my name in the photo. In the motion, Leslie claimed that the text exonerated her and proved that I said that I never wanted to be part of the lawsuit. Leslie said that the text message was undated. My name appeared in the first lawsuit filed by Wayfarer against the New York Times, but in the January lawsuit against Blake Lively, my name and photo were redacted. Leslie used this text message with Freedman in the context that I sent this prior to either lawsuit being filed. So there you go. He's saying that text message where he's like, please don't say I said this. He's confirming what that was all about. That, it could have, he didn't want to be revealed, and he accidentally was in the New York Times one, but he'd asked Wayfarer to redact his name and photo, and they did that. But Leslie Sloane used the text message and distorted the context behind it. This text message with Freedman was followed up by a text message with Nathan in which I agreed to let them use the text so long as my name and photo were removed, which they were, which we saw. We saw that message, that request. And we saw him say, yeah, you can use them. And then there's this one. So this is an email sent to right, okay. This is a text message from someone at the Daily Mail to James Vituscka. Well, he's in it, but other people are copied in. So this is regarding a deposition subpoena. This is from someone higher up in Daily Mail making a decision, and they basically say, I'm hesitant to waste Daily Mail's money on a call to even discuss this outrageous proposal. James should not be apologising for an unauthorised inclusion of the text message in the complaint. If it were, as they know, unauthorised, why should he apologise? Not his fault. Also, we should not be connecting him with harm. And as you already know, James thinks she has lied. She is not a trusted source. They're talking about Leslie Sloane here. He is comfortable saying what we proposed. If they were smart, they would take it rather than having him go on camera under oath at a deposition and talk about the time she gave him misinformation and even had to correct herself, admit she misspoke, or what she said was not what she meant. So, yeah, that's the issue there I'm having with that. So let's go back to. So those are the problems I have with Judge Lyman relying on these declarations. If we go further down, right? Okay. So where is it? Yeah, okay. So in pink here, right, the Federal Rule of Civil Procedure 11, right? So he's saying it's applicable when the motion is made for sanctions based on frivolous litigation in federal court, which we know. Rule 11 requires that a factual contention must either have evidentiary support or, if it does not, be specifically identified as an allegation likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. It also provides for sanctions if a pleading is made for an improper purpose. Now, I have a problem with some of these words. He's stating what it is. I do understand that, but there is evidentiary support for Wayfarer, where Wayfarer got their opinion and beliefs from. It may well have been mistaken, but James Vituscka clearly doesn't believe that too. So he then goes on and says Sloane alternatively seeks sanctions under the court's inherent powers. Sloane's submission, if credited, outlines a potentially troubling course of practice by the Wayfarer parties or their counsel in this court. I don't love that. I don't love that they're saying this, that he's saying this, sorry. They allegedly filed a false claim in this court by claiming that Sloane told Vituscka that Blake was sexually assaulted, despite receiving text from Vituscka prior to that filing that affirmatively stated Sloane made no such statement. In doing so, they made Sloane collateral damage in their battle against Lively. The court has inherent power to impose sanctions for bad faith conduct, even where the conduct could also be sanctioned under the statute or the rules. I don't love these opinions that he's given. And at the time he wrote this order, he had access to the full chain of text messages. It was included in one of the dispositive filings because when the exhibit I just looked at with all those messages was one of the unsealed exhibits. I can't remember if it was the motion for judgment on the pleadings or for summary judgment. I believe it would probably be summary judgment, but he's there on the docket. He's got them access to them in front of him. He had access to them before they were unsealed, so he could have read the full context. And I cannot believe that. I mean, there may well be more. Have any of those exhibits from Without a Crystal Ball been sent in? I don't know. We don't know because they're not public. They're not as part of a motion, so they're not on the docket. But I can't imagine. I would be stunned if they have not been. Okay. So he does go on to say, however, the court must exercise caution in invoking its power, and it must comply with mandates of due process, both in determining that the requisite bad faith exists and in assessing fees. And he's saying, look, Sloane could have followed the procedural requirements of Rule 11, served a copy of the sanctions motion on the Wayfarer parties, and given them an opportunity to withdraw the allegation, and then, only if the allegation was not withdrawn, filed a motion for Rule 11 sanctions. The timeline in this case confirms that Sloane could have pursued that course. So he's saying, look, you have a strong case for Rule 11 sanctions. I think we're past that now, though, because, they do have to give Wayfarer an opportunity to withdraw the allegation. And that's what Lively did. That's the safe harbor letters that she filed before she filed Rule 11 sanctions. So we are now past that anyway, because obviously the Sloane did not raise the issue. No sanctions request was filed. And, the judge went on to look at the motion to dismiss and dismissed. So in green, I've kind of, because this is where the judge kind of slaps Sloane down a little bit here as well, which I'm not prepared to go as far as to give him credit for, because this is his job. But I will I'll give him a different highlighter just to differentiate. On April 30th, Sloane filed a discovery motion that included as an exhibit the December 2024 complaint filed by the Wayfarer parties against the New York Times in California State Court, which included at least one of the text messages from Vituscka that Sloane alleges demonstrates the falsity of the allegations against her. Sloane obviously had personal knowledge of what she said to the Daily Mail. If she believed that the Wayfarer parties had engaged in sanctionable conduct, she could have raised it with them and then with the court under Rule 11. She chose not to do so. In this case, the court will not allow inherent powers to substitute for the procedural mechanism of Rule 11. And that's probably the one thing I do agree with him on. Like, he is saying, well, look, you're not substituting one thing for, because you didn't do something else. So it's not a job well done, but, it's like, yeah, okay, fair enough. But then he goes on to deny Sloane's attorney's fees and costs, but he denies it with prejudice to renewal by way of a formal action. He's basically saying, do what the New York Times did, bring it as a state claim, or she could file it in federal court too, because he has explained all that as well in this motion. So one way or another, Leslie Sloane is coming back, and she will bring this back again. And he's basically told her, this is how you do it. So no, I do not see this as a win. That was a long-winded way of explaining it, but I'm pissed off with James Vituscka because I think he has created an absolute shit show for Wayfarer. He really has, and he has actually pissed me right off. And I don't even try to hide that in anything I put on X about him or anything I say in a video. He's sitting there like filing a declaration saying, I did not say this and I did not authorize that. And then he's sending text messages to Melissa Nathan going, oh my God, but it was false. It was not true. I want to get it withdrawn, and telling her, here, have all these messages, use them if you want. And then after that, he's then going and filing another declaration saying, I made it clear that, this was not true and that was not true and I did not say that. And it's like, what the fuck is wrong with this guy? What are you doing? And to be honest, I'm kind of glad that he lost his job in the end. And I know that sounds awful, right? But I mean, there was other reasons he lost his job. He lost his job because he caused damage to an elevator, and there's a few other things. It's all in my X thread, which I'll put a link to in the description of the video. But in a nutshell, I'm kind of really pissed off with him. I am, because I think he has created a big problem here. He has said something which made Wayfarer then bring in Leslie Sloane as a defendant, and then he's gone and backtracked on it. Well, he is a witness that needs to be relied upon, because he's the one who has informed Melissa Nathan and Brian Freedman that Leslie Sloane made the statement for which they went and sued her for. And as a result of that now, and then going back and saying, no, I didn't say that. That's not what I meant. I didn't say that. No. Wayfarer now having to deal with this bullshit of, she's now seeking, not unreasonably in many ways, attorney's fees and costs. And then they're going to have to deal with that. And it really annoys me because that would not have happened but for James Vituscka. So I've seen some people have some sympathy with this guy. I really don't think you're getting angry enough with him. I don't. I think he has caused so many problems. Okay, so let's go to the next part. So the other thing I'm getting in my comments is, oh, Blake Lively, her lawyers are working on contingency fees. So I want to clear that up. I don't think they are. I don't. A contingency fee, you see it more often than not in like accident and personal injury claims and things like that. You can see it in other instances too, but basically it is a in the UK, I think it's going to be similar to the US, but in the UK it would be a lawyer's would work on basically a no win no fee basis quite often. So there is a huge risk that they're taking if they don't win the lawsuit. And they kind of balance that out. So there's a couple of things that you need to have in place for a lawyer in the UK to take on a case on contingency fee agreement basis. Firstly, the prospects of success are going to be high, right? They're going to be, it's different for different law firms. It's nearly always the bare minimum is 50% chance of winning. You've got to at least have that 50% chance. Most companies will actually only accept, once they've assessed the merits and everything, they've got to look at everything. And, they're not just taking your word for it. They want to see agreements. They want to see text messages, any CCTV, anything that will help prove your case and they want you to be very clear. Is there anything that could, effectively undermine your case as well? Okay. And most companies will not take on a case on a contingency fee basis unless the prospects of success are at minimum 75 to 80%. So 50 is just the absolute lowest, because if it's not even got half the chance of success, then you're not going to take that risk. Now, what happens is if it's agreed to take on that risk, right, you do what is necessary. You do not do over and above, because you might be doing all that work for nothing. You will do what is necessary to prove the case and win. If you win, you then have like a percentage of any fees or damages awards, right? You have a percentage of any damages awards. In the UK, sometimes we have after the event insurance as well, where a client will pay an amount for like an indemnity policy, basically, but it's after the event. So the problem has already happened. Normally, insurance would work before the event. Like, you insure your house in case it catches fire. You don't insure it after the fire has already happened, because the insurance company won't pay out. But in the legal sector, you can have after the event insurance. I don't think Blake Lively's team are on contingency fee basis, right? And there's a few reasons for that. Is one, a case is not that strong. Now, when you're slicing and dicing text messages, it may look strong, but there is always the other side of the argument. The other side is, why would they need it? They've got the money, they can afford it. Why would they not be paying this? Now, I've heard people say, "Oh, it's because they have assets, but not liquid assets." I'm sorry. I think Ryan Reynolds and Blake Lively, between them, still would have enough liquid assets to cover the attorney's fees. I mean, they're in the millions, but maybe 10, 20 million. They're not going to be any more than that, and those two have definitely got that in their bank. The other reason is, look at all the work. Blake Lively's got actually 4 law firms working for her, because you've got the 2 main ones. You've got Wilkin and you've got Manat. You've also got Leslie Sloane's firm, Sigrid Macaulay, and you've also got the Texas law firm as well, with Laura Prather. Then on top of that, you've got all the company attorneys as well. So, but Manat and Wilkie, I mean, they are just throwing in so much work. They are doing so much work. And when I got subpoenaed, and I know this was a bit of a consensus amongst various content creators, but when we were actually dealing with Manat, yeah, it was with Manat. When we were dealing with Manat, we did not get any impression that they were trying to mitigate their costs, which is what would happen if a law firm was working on a contingency fee. They were just racking up costs on costs on costs. It's almost like they didn't care how much work they were doing, because someone was paying the bill. And we actually said that to each other. It's like, wow, they are just working to bill their client. And if you're working on a contingency fee on this case, and by the time the amended complaint come out, right, even if you went in thinking, oh wow, she could really win this, by the time the amended complaint come out from Wayfarer, you really know that actually those odds have just slipped drastically. You are not then going to go and waste time subpoenaing 107 content creators for nothing, quite literally for nothing. That's work. That's, you're paying for that. You are not going to, waste time sending someone to Las Vegas to go to court with Perez Hilton to get nothing. And I've said this all along. The only reason they're still after Andy now is because of the documentary and the fact that he spoke to cast and crew. That's what that is all about, and they want that information. But they have, and I don't think you can't reasonably say, oh, well, she filed all those sanctions fees, sanctions requests and trying to get her attorney's fees. You can't rely on that. It looks promising, but you can't rely on that because getting your attorney's fees paid as part of sanctions is kind of like it's quite an extreme move, and it's often quite a last resort situation. Normally doesn't happen on the first round of sanctions either. So I don't think that they've filed all of that. And as you saw in the text message from Melissa Nathan, when she was saying to James Vituscka, oh my God, they're just, I'm drowning in all the stuff they keep hitting us with. So, and don't forget, the attorneys were working for two clients. They were working for Blake Lively and Ryan Reynolds. And Leslie Sloane has paid her attorney's fees. That's why she wants them back. She has paid them. So I was getting multiple messages about this in my comments, and I was like, where is this coming from? So I had a look around, and surprise, surprise. Now, I'm not trying to be, I've been critical of Without a Crystal Ball. I've had good reason to as well. She's off the mark on this one, right? Now, there has been some stuff she's done that has been really good, so I'm not criticizing her personally or direct, I'm not trying to be, horrible here. This is my opinion, right? She may have a different opinion. She says she has a source. Now, I can't see what source is telling Without a Crystal Ball, oh, yeah, they're working on contingency fee. Because that's work product. That's attorney-client privilege. That's privileged information. Blake Lively may have, and Ryan Reynolds, as part of unions that they're with, or, like they may have indemnity insurances, okay, which may be contributing to this, similar to how Amber Heard did. She had two insurance companies who, funded her lawsuit against Johnny Depp. And then there was a big lawsuit amongst the insurance companies. And we know that's the case. Wayfarer have got insurance companies. They've got three. And one of them is currently, I think one is in a lawsuit with them in New York. And I think Wayfarer are suing the other two in California and intend to add the third insurance company to their California suit. But not perfect, because they're not paying out. But they've got the insurance companies there. So, and I would not be surprised if Blake Lively and Ryan Reynolds do have that. That's not unusual. It comes with the job sometimes. But a contingency fee, a no-win, no-fee basis, absolutely no. It does. It again, there is in my mind, maybe a 5% chance that's a possibility, but this lawsuit does not fit that kind of profile or, the objectives of a contingency fee lawsuit. So that is just my opinion, though. I wouldn't run with this. I just wouldn't. We've had nothing confirmed about it anyway. And I'm sorry, I've dealt with Without a Crystal Ball long enough now to know, not to just assume that she has sources. She may well do. And yes, she was talking to James Vituscka, and we saw the text messages and things, but the sources could be way off too, even if she has got sources. But there's no evidence here, so I'm not going to kind of entertain that. But this lawsuit is not the right type of lawsuit for a contingency fee agreement. There are other ways that this is being funded. The only other thing is, I've had people say to me, with the fact that Brian Freedman and Kevin Fritz got reprimanded for the Rule 11 sanctions request, should Wayfarer sue them? Have they let Wayfarer down? I would just say no. No, they have not. Was the complaint, any of the complaints from Wayfarer, were they up to legal standard? Were they your typical legal filing? No. Actually, let's go here. Okay, so this is one of my first posts on as a content creator, I guess. This is my breakdown of the New York Times motion to dismiss. Okay. And one of the things I said in this first paragraph, the layout of the filing is visually amazing. This is about the New York Times motion to dismiss. It's visually amazing and resembles what we get taught in law school. When people, particularly lawyers, point out that the lengthy filings from both Lively and Baldoni do not look like complaints usually look, this is what they mean. The use of indexes, case law lists, and methodical setting out of case makes the judge's job much easier to understand the arguments being made and what relevant supporting law is being cited. I have to give props to Catherine Bolger for how she's written this, as it's much easier for me to follow the legal side of the arguments. So, and then I did actually when Lively's filing was all over the place and it was hard to understand who was being sued for what. Very little supporting law was referred to. It was clearly intended for PR. And then I said, Baldoni's was a little bit more methodical, but it had to respond to Lively, so was also unorthodox and written with a PR priority in mind. I'm hoping the filing will sharpen up as the case progresses. That is what I wrote back on the 3rd of March, 2025, last year. And that was my opinion of, the complaint from Lively and Baldoni versus proper filings, as I went on to call it, by the New York Times. So was Freedman, did he write a good complaint? If I'm just looking from a legal perspective, no, he did not. But this is a Hollywood case. Their image is everything and above all. So when Lively filed hers, it was all about PR. That's why it went to the New York Times first. Baldoni had to respond, right? And we weren't there for the discussions, okay? We don't know what the objective was, but Freedman is known for being very much he will restore your reputation kind of lawyer, and he did, right? So I do not believe for a minute that the clients would not have agreed to the complaint being filed as it was. And I do think as well, I do think that, at the end of the day, Freedman did exactly what the objective was. And I have said this over and over again, right? Love him or hate him. I love Freedman. Now, there's other people I prefer for their legal drafting. But when it comes to the PR, I love Freedman because he knows exactly what needs to be done and he goes and does it. Now, you have to go back to before the complaint from Wayfarer with their side of the story come out. You have to go back to when the New York Times article first landed, when Lively first filed her complaint, and remember the public sentiment, right? All these celebrities coming out going, what a piece of shit. He was having his awards revoked. His life and career was over, right? And there wouldn't have been much clawing back because many people, not everyone, but many people didn't actually know who Justin Baldoni was, or they'd never heard of Wayfarer. And now we all do. I already knew Justin Baldoni, made that clear. It was Blake Lively I didn't actually know much about at all. I really didn't. I'd never seen anything she'd been in. I only knew her as Ryan Reynolds' wife, which to me is not much of a flex, especially these days. But I didn't really know much about her. The only thing really that I knew of was that she had dissed our Princess Catherine on X, and that was about it. So I already had the opinion that she was an asshat for that. But Freedman's job, I believe, well, I don't know for sure, so I'm not stating this as a fact. My opinion is someone has sat down and gone, oh my God, because sexual harassment allegations are so serious, and you could see how hard Ryan Reynolds, now we've seen the text messages, we see how fucking hard he tried to turn the entire industry against Justin Baldoni and Wayfarer. Like, from the talent agencies to the PR publicists, they used the mainstream media, big outlets, and then they were getting all their friends, their A-list friends and directors and God knows who, and saying, oh my God, this guy, what a predator. That is what Freedman had to work against, right? So do I think he did a bad job? No, I do not, because he achieved the intended purpose, right? He'd made his statements, right? Probably took a bit of a risk as well doing so, but, because he did walk the line with them, I think. But he made his statements, and then he drafted that complaint. Then he drafted the amended complaint. And let's remember, guys, right? The most important thing to remember when we're talking about, oh my God, well, Wayfarer should sue Freedman, he let them down. No, he fucking didn't. Do you know why? Because he got that timeline out there on the docket, right? And that got all of us internet sleuths. We have now found so much. We found evidence of past behavior where Lively has tried to take over movies. We have found past evidence of, Ryan Reynolds practically admitting to sexually harassing other co-stars, or getting his daughter to repeat, repulsive lines for the sake of a movie. We have gone through the whole fucking mill. And we have absolutely combed through not just their lives, we have combed through all of the lives of the co-stars as well, who almost aided and abetted Isabella Farah, Brandon Sklenar, Jenny Slate. We have gone through them all. We've called out all of their bullshit. We have found important things that have made a difference, that have been a game changer for this lawsuit. And that is because Brian Freedman drafted that complaint in a way that timeline got out and got to us. And when we got hold of it, we went nuts. Like, oh, let's have a look. What happened on that date? We now know what Taylor Swift's involvement was. We now know what Matt Damon's involvement was. So we also know a lot more now about Colleen Hoover. And that is largely in thanks to the fact that Freedman did a fucking ace job, a stellar job, in my opinion, of handling the PR. And the thing is whilst in a normal everyday lawsuit, if I was in a lawsuit with, my neighbor across the road, no one would give a shit about the PR. But this is Hollywood. Their image is everything. So the image is currency even. So actually, it makes sense for someone to come in and deal with the PR, because Blake Lively was dealing with the PR. So why shouldn't Justin Baldoni have done the same thing? And at the end of the day, they try to hide the fact that they are these awful people. But we now know the truth. We now know the truth. And there have been so many fines that have been game changers because of that timeline. And we've had Brian Freedman has come out and thanked the sleuths. He has literally come out and said, thank God for the sleuths. And I think he means it. I think he genuinely means it. Not because he probably wouldn't have found this stuff, himself, but this is what happened with Amber Heard as well. Like, we found, not we, because I wasn't part of that, but, they found some stuff that was like pointed to her being actually an awful person, and it went public. And whether win or lose the case, the world got to see the real Amber Heard. And the same thing is just now is happening to Ryan Reynolds and Blake Lively. So no, I don't think that Wayfarer should sue Brian Freedman for anything, nor do I think he's failed them either. I think they knew the complaint would probably be dismissed. I think they half expected that in many ways. It was not well drafted, though. If if you're asking me for like, oh, what's your opinion from looking at it from a legal perspective, I said a year ago it wasn't that well done. This is what I'm expecting. When I looked at the New York Times, this is what I expect a legal filing to look like. This is what I got taught in university. So I'm not surprised. I think the reprimand that they got was not unreasonable. Judge Lyman could have, in theory, gone further, but he did not. I think he gave Lively something. Again, I'm not counting big wins. I do think that I think he had to do something because I think he had to do something, and it could have been worse because he could have sanctioned Wayfarer parties kind of individuals themselves. But he did not. He sanctioned the two law firms, but I don't think it was overly unreasonable, because it didn't make sense that they were suing. Like that Melissa Nathan, for instance, was suing Blake Lively or Ryan Reynolds for breach of a contract that she was never a party to anyway. That did not make sense to me. I'm going to go one further, actually, though, and just go back to Blake Lively's original complaint. So this is her original before Jed Wallace come on board. But we could apply the same argument to some of the causes of action against Jed Wallace. But if we look at this is her 7th cause of action in her original complaint, aiding and abetting. And she has filed that against Nathan, Tag, and Abel. Now, did they really aid and abet harassment and retaliation more than a year on from said harassment? I don't think so. How could they? Why would they? This is a stupid cause of action. I'm just looking here. Intentional infliction of emotional distress. Really? Did they? It's such a stretch. False invasion of privacy against Nathan, Tag, and Abel. Yeah, I'm not buying it. Sorry, I'm just gonna keep looking at other causes of action, see what else there is. I mean, she's been a little bit more careful with who she's suing because, as you can see, like retaliation in violation of PIHA against It Ends With Us Movie LLC and Wayfarer. She has not added Tag or anyone else to that, and that's the right thing to do. And the thing is if Wayfarer had been a bit more careful, then yeah, okay, they may not have got this reprimand. So was that probably something that could have been a bit more care could have been taken? Yeah, probably. That's about as far as I go with that, with my criticism of that. Yes, so it's just those causes of action. But honestly, right, can Blake Lively honestly look with a straight face and say that Melissa Nathan and Jennifer Abel and Tag aided and abetted harassment? Of course they didn't. They were nowhere near the harassment happened allegedly in May 2023. Melissa Nathan wasn't even brought on until the end of July, start of August 2024. So what the hell is she aiding and abetting? Now people will say, oh, well, yeah, but, if there was a smear campaign, then she was part of that. Well, okay, but she wasn't brought on for that purpose. I have seen absolutely no evidence that says, I want you to come and help me retaliate against Blake Lively. She was hired as a crisis PR because there was a fucking crisis. That was that. And that was caused by, the bickering and backstabbing between Lively's camp and Wayfarer's camp. The publicists acting shitty towards each other. And then the organic hatred of Lively, the way she portrayed the film, the alcohol promotion and everything else that goes on. I mean, it doesn't take a fucking rocket science to explain why no one liked Blake Lively during that promotion of the film and the way she portrayed Lily Bloom. She was awful. She was the wrong person. That is actually where her quote unquote smeared campaign actually started, was the news that she had been hired into a role which in the book is supposed to be a much younger person. She was never right for the role, and Colleen Hoover's fan base made that abundantly clear that they did not agree with her hiring. And they were still reeling off the fact that Colleen Hoover had tried to market the book with fucking nail polish and colouring books. Like, what is it with these women glorifying domestic violence? And it just really pisses me off. And then I've had people say to me, well, it's not fair. Why are Wayfarer not being sanctioned? And the simple, short answer to that is that, not Wayfarer, why are Blake Lively? They're just as bad. They've done all this stuff, the bans and blah, blah. Why are they not being sanctioned? And the simple reason for that is Wayfarer have not asked for it, and they've got to ask for it. So I would love them to ask for some sanctions. I really would. I was hoping they would do more with Van Zandt. They have not done it. It may come up in the pre-trial motions. Maybe, like motions in limine, for instance. We might see, a request for a motion in limine to limit, what text messages can be used because of the way that they were obtained. That's my best guess. But would I have liked to have seen, something, given that Brian Freedman said, oh, well, we're going to take every legal action available to us? And he hasn't. And yeah, that is infuriating. And I do wish that they would fight a bit harder. But they're not that way inclined. And we all have to just accept that. We can all be outraged and upset, but it's their lawsuit. And if they are not inclined, I mean, it's really hard anyway, because you don't want to go hard against someone who is accusing you of sexually harassing them. It's not a good look when, come the trial, you get all of these, you get the lawyer standing up in front of the jury saying, but you did this and you did that, and you filed for sanctions against our client because she brought this action, etc., etc. And it's they're already going to do that with the counter claim. They're already going to say, oh, you retaliated by suing our client. And it's just difficult. And it worked, and it can backfire in that situation. In the Johnny Depp case, I think it was, yeah, Amber Heard, came as a kind of like, she, wanted to be seen as a victim, blah, blah, blah. But, she tried to get one of the, was it the therapist or the nurse, fired or struck off. She filed an arbitration and some threatening letters to Johnny Depp, but she didn't disclose them up front. And so when it come up at trial, everyone was like, oh, wow, we did not know that. I thought you were the weak victim here, and it's just not, I don't think it would be a good look at this point for Wayfarer to go filing stuff then to kind of, retaliate, not retaliate, but that's the wrong word, to file stuff against Lively. And I think they're being very cautious about that, because actually right now, as it stands, if this goes to trial, if it does not get totally gutted, I think some things will go, but I'm not hopeful that everything will get totally gutted. In fact, I'm quite concerned by some of the things that Lyman has said, especially in that Sloane order. I don't like the way he's viewing this case. But if it gets to trial with all the evidence, right, it is out of Lyman. It's not Lyman's decision at that point. It is down to a jury. And Wayfarer have got a decent chance of making good arguments and persuading the jury that they didn't do anything that they are accused of by Lively. If they start filing sanctions though, and you start hitting her and her counsel with that, start being overly critical, that may cause a problem. That may not be a good look. And that's just my opinion. I think that's why they're treading very carefully here. I have no doubt that deep down they'd love to file for sanctions or, request some things be stricken, etc., etc. But, at the end of the day, they're kind of playing the long game is how I'm viewing this. And it's a good strategy. It's a good strategy because they have sat on things, right? That like that PJ letter, they have held onto that PJ letter for months, and now it's come down and we're all recoiled in horror and gone, "Oh my fucking god!" Right? And there are going to be so many more moments because there is a lot more evidence. I'm telling you now. But when you get to the trial point as well, you want them to, maintain their composure, right? Continue to be the reasonable person in the room, because God knows we've got enough evidence now of Lively being completely unreasonable. I mean, she's saying she was powerless, yet this is the same woman who filed, 10 motions for sanctions? This is the same woman who went after, apart from two males, I think it was, that I know of, I think all of the other content creators were women. Most of them were women who've actually just spoken out over their own domestic violence situations. So that's the kind of person Blake Lively is. And it is going to show. So trust the process, guys. I know everyone wants to see, her get a comeuppance. I think she will. And I mean, she has in many ways anyway, because her reputation is, in tatters now, not because of any false information or a smear campaign or Wayfarer. It's because the internet sleuths have found all of their past, interviews and various things that her and her husband have been part of and gone, oh, look, she really is an awful person. So things that previously, just kind of slipped quietly into the background are now being brought back to the forefront. And we're all seeing it again and looking at it with different eyes. So trust the process, trust Freedman. I will say that. Do trust Freedman. He knows what he is doing, right? He has done the PR bit. He has now stepped back. Then Fritz took over a lot of the filings. And then there's been a bit of a step back there. And we've got Alexander Shapiro and Jonathan Back, who are, now you're getting the refined filings, the proper legal refined filings that are making an impact. I think everything's going really well. And I think Wayfarer know it too. So, but I'm going to wrap up there. I will do something separate for the content creators filing because I think I have some emotions and some things I want to kind of say about it. But I just needed to take a day or two to think about it. But thank you for listening, though, and I will I'll probably have another video tomorrow. Take care, guys.